that just finished talking about digital assets and regulation, and now we've got the Commissioner Peirce, crypto mom herself, to join us for today. So let me just give 30 seconds on Commissioner Peirce's history at the SEC, and then we'll dive right in with a few questions. And again, Commissioner Peirce, thank you so much for joining us today. Okay, so Hester Peirce was appointed by President Donald Trump to the SEC and was sworn in on January 11th, 2018. Prior to joining the SEC, Commissioner Peirce conducted research on the regulation of financial markets at the Mercatus Center at George Mason University. She was a senior counsel on the U.S. Senate Committee on Banking, Housing, and Urban Affairs, where she advised ranking member Richard Shelby and other members of the Committee on Securities issues. She served as counsel to SEC Commissioner Paul Atkins. By the way, when Commissioner Peirce was serving Chair Atkins, I was serving another SEC commissioner, so we got the opportunity to work together as very young lawyers. We're still young, by the way. Commissioner Peirce served as, she also worked as staff attorney in the SEC's Division of Investment Management. She was an associate at Wilmer, Cutler, and Pickering, now Wilmer Hale, and clerked for Judge Roger Andwelt on the Court of Federal Claims. But by the way, notwithstanding the Yale Law School, the most impressive credential to me is she's also a Buckeye. Did not go to Ohio State, but hails from the great state of Ohio. So Hester, thank you so much for joining us this morning.
Well, Keir, thanks for having me, and I'm glad you mentioned that we worked together all those years ago. It's been fun watching your career since that time. I've always been impressed. But I'm honored that I can be part of today's event. And I'm sorry that I'm not Richard Gabbert, who is the head of the crypto task force and would have been here today were it not for the shutdown. I still have to give you my disclaimer, which is that my views are my own views as a commissioner, not necessarily those of the SEC or my fellow commissioners.
Great, thank you. We appreciate that. And again, so thrilled to be here. Your humility is just very much appreciated. Okay, so I'm going to get us kicked off, and then we've got this all-star panel who basically, we crowdsource the questions. So I'm going to kick it off, but if you all want to jump in, please do. You all saw the questions that we shared with Commissioner Peirce in advance. So this is a total softball, but how does the SEC plan to provide greater clarity on when digital assets are considered securities versus commodities or other types of assets? Maybe that's not a softball, but it's a question.
It's not a softball.
Yes.
Yeah, because the government is shut down, so we really can't do anything right now, which is unfortunate. It has really put our timelines back, which is now that it's been a month, it's actually a pretty material change. But I think we are looking at ways that we can provide more clarity. We've provided some, I think, through staff guidance about some things that fall clearly outside the SEC's jurisdiction, but looking at a way that we can provide some interpretive guidance about how we think about what fits within which bucket. And I think that could be quite helpful to people just to allay their fears. I mean, you've already gotten the top level change, right? Chairman Atkins says that most digital assets that we see now are not securities, whereas Chairman Gensler said the opposite. So we have definitely changed how we look at things, but I think providing some more context around why that is would be helpful for people.
I think this group would agree. I think you mentioned the guidance that we now have from Chair Atkins. I think one of the questions that we've debated really over the last 2 days as part of this conference is around durable change. And so when I think about, this panel talked about the Howey test. You've got case law and years of development on that case law. How do we create durable change? And to be specific, would you prefer to see some version of Howey codified in a statute? And if so, what changes would you make to the case law that's developed around the Howey test?
I wouldn't mind seeing some codification of Howey. I don't think that's really a crypto specific concern that's driving me to say that. I think that there has been some uncertainty around what exactly gets pulled in and why with Howey. We've used it, for example, with pyramid scheme type things, which again, trying to capture activity that we feel should be regulated, but maybe doesn't naturally fit within one of the buckets in the definition of security, so it kind of gets shoved into investment contract. And I think the stretching that we've done to try to use the Howey analysis to pull in crypto really illustrates for me that it would be helpful to have some more clarity around what Congress intends us to capture. And then if there are other things that we need to capture, they could maybe create separate categories for that. But I mean, that is not really my primary objective, and I don't know whether or not that's something that the legislation will include. I think there's a lot that can be done without trying to revisit Howey or codify some definition of investment contract. I think there are just some sensible lines that we can lay out that would go a long way to providing clarity, whether that's in regulation, which is pretty durable, or whether that's in legislation, which is obviously more durable, and I think durability is something we should care about.
All right, I'm going to ask one more question, and then I'm going to look at my esteemed co-panelists. One question that we came up with is, how much token classification do you think the SEC can address without market structure? So changing from the product itself into kind of the ecosystem in which that product could be bought and sold or held.
I mean, I think we can do a lot with the authority we have now. Some of the conclusions that we come to may be that they're not securities, and so some people might decide that they want some other regulatory framework for that, in which case that may be something Congress needs to do through legislation. But I think we can do a lot of the classification with the authority we have now.
Okay. All right, panel. Mr. Brummer.
Okay, host. Okay, so just maybe a little pickup on that last idea, which is kind of we live in Washington. We have slowdowns at some points in time. When you think about clarity, and I try to tell our friends here in New York, it's a little bit sometimes like the weather. Oh, it's a little more sunny today, and clarity's a little cloudy today, and so it's a little bit difficult to sort of figure out where the puck is ultimately going to land. From an agency perspective, that gives you some really interesting choices. One is, do you sort of direct the guidance processes towards providing kind of a temporary rail towards the expectation that you will have legislation sort of to queue it up, or is your mindset regardless one way or another, we're kind of going down and creating the kind of clarity and rulemaking that's going to be durable and effective? I mean, like, to what extent does the legislation or the prospect of legislation impact how you go about doing your job when it just sort of changes from day to day or month to month as to the timing and perhaps even likeliness of that legislation?
Well, we certainly want to be respectful to the role that we have, which is very different than the role that Congress has. And so I think we're always trying to be helpful to them as they think through the challenges of writing legislation. And it is very challenging. I think it's quite impressive, the amount of work that Congress has been able to do on this topic. The House putting together its framework, the Senate is working hard on its framework. So we want to be as helpful as we can to that effort. But I think under the authority that we already have, we not only can do some of the work in providing, a categorization and providing people some rails or some ways that they can register things, and really giving life to the comment, come in and register, right? We can do some of that work, and we don't need new authority to do that. And I think it's not only something that we can do, but something that we should do, because it's authority that we already have.
So I'll jump in on a question that actually we had just have a conversation on this panel about a few moments ago. So first of all, let me say, I'm not sure I'm a fan of digital assets. I'm not sure, but I am definitely a fan of blockchain. Like I love the promise that blockchain has, not just from a financial product perspective, but also the utility of blockchains. One of the questions that we were just talking about was, at what point or to what extent should the blockchains themselves be regulated as opposed to the products that are created and trade or are held on blockchains?
So, Kier, you're not going to create Buckeye Bucks?
I would love that. I'm all in.
Well, I think so blockchains can be a lot of different things, and they can be used for a lot of different things, and there are different types of blockchains. So I think if you have a public blockchain, that there isn't a need to regulate a public blockchain. You may regulate what people use that blockchain for, or you may have a blockchain that is essentially operated by a small group of people, and you may regulate what they do. But I think in general, I'd say regulating blockchains is not the right way to go.
Marie?
Good answer.
Yes.
We just talked about it, so
Actually,
I feel like
better
we got
answer.
the answer right.
Yeah, I think Corey won on that one, by the way.
Is the expert, and
Yes.
that made me feel better that I passed the exam.
Anne-Marie, did you?
Maybe I passed
Do you
the
want me
exam.
to ask my question?
Yes.
Oh, I'm sorry. I'm so caught up in this. So one of the other things that we talked about on the previous panel, Commissioner Peirce, was the amazing work the Crypto Task Force has done. The way that you and the team have been so open to industry views, and I think maybe one of the most iconic moments in that journey for us so far has been your, there's got to be some way out of this statement and your request for information from the industry. And I was saying there was, I think at the end of the day, maybe like close to 80 questions and sub-questions across that request for information. And I'm just curious, like, were you pleased with the industry response to that initiative, first of all? And then what were the areas that surprised you the most from a feedback point of view, if there was anything surprising?
Yeah, well, I am pleased that we've gotten a lot of great responses and substantive responses. I think that some people are still sending those in, which I encourage because they're still very valuable. I don't know that I was surprised by anything, except that I have been, I guess, a little bit surprised by the amount of interest there is in tokenizing traditional securities, and maybe I shouldn't have been surprised by that, but that has been sort of one big theme of the feedback that's come in through that request, and also just more generally through our roundtables and meetings with people.
One of the things, and if I can ask a second part of that, one of the things to that topic that I think is really important, and an idea that that I had that seems very antiquated because I was at the SEC a million years ago was, and I spoke to Chair Atkins about this as well, is how do you approach that issue, right? So you have all these different market participants that want to do things differently potentially, and infrastructure that could be completely updated across the board using blockchain technology. And do you do that in a piecemeal fashion? I mean, one of the things I was thinking about from when I was at the SEC was that Trading and Markets put out Market 2000, which was just a holistic view of how electronic trading can change the market across the board. Do you do something like a Market 2000 around blockchain infrastructure for public equity trading, or do you try to do it piece by piece? It's such a huge challenge, and there is so much interest in tokenized securities trading, but how do you solve that versus a holistic approach versus a piece-by-piece approach, if you have a view of that?
I am glad that you pointed to Market 2000, because that is something that it's worth going back and thinking about. But I'm a little bit reluctant to have this project just be one of producing reports, because I think people are really eager to try to experiment with things. And so my preference really is to let experiments happen with the idea that the ones that gain commercial viability will be able to continue, and will be able to continue without a break, right? So they'll be able to run an experiment and then work themselves into, to use the word of the day, a durable set of rules that they'll be able to operate under. But I think that, as you know, Anne-Marie, this is not an easy thing, because trying to tokenize securities touches on just so many different aspects of the regulatory framework. And it's somewhat nice that it's coinciding with a chairman who is thinking more broadly about equity market structure rules, which have tended to be quite top down, from my perspective, quite prescriptive and unnecessarily so. And so maybe this is a way for us to challenge those prior rules and say we ought to look at those and make sure that they are that they're working as we want them to, and that they're not too heavy-handed. So I think that's how we're trying to approach it, is allowing people to experiment and then figure out which experiments are successful.
It's going to be very exciting. It's interesting to see, like, if every national exchange will come to the same place, right? Because you have NMS and you have to do order flow in a certain manner, and you've had centralized intermediaries that exist right now that are not blockchain enabled. And so that's so many really cool things to solve for, and we're very excited to see how you move forward on that.
I think it is kind of interesting because there is already a lot of experimentation. I was just over at Swift headquarters 2 days ago, and I gave a talk there, but then I just literally sat around for 5 hours watching the banks and stock exchanges giving internal demos as to what they're experimenting with. Is there a sense, like, how I mean, there is so much going on. Do you prefer for folks to sort of send in on Instagram, pictures of their demos to you guys? I mean, what's along with their Nelly videos? No, I mean, like how exactly, do you think or would you prefer for these kinds of experiments to be communicated to you as they are getting underway?
Well, we certainly love demos. I think if people want to come in and do demos or invite us there to see their demos, we're open to that. As I'm seeing it, people who want to do experiments in U.S. markets are going to need some sort of exemptive relief. And so I am encouraging people to come in and talk to us about that, and thinking through before they come in what kind of relief they might need so that we can think about how we could provide that to them. There is a lot of experimentation, I think, as you said, that's happening internally, and some is happening outside the U.S. I would like that to be happening in the U.S., but I think we will need to have those conversations beforehand.
So check mark Instagram.
Yes.
Okay.
So just to maybe go in a slightly different direction, I think one of the challenges when you think about digital assets, especially as compared to more traditional financial instruments like securities or bonds, is that there can be both an investment quality and a utility quality, right? There are some tokens that the primary value of them is how they're used, right? And then others, for at least in the eyes of some of their holders, it's about the investment opportunity that those might create. Like, so what are the dividing lines from your perspective or from the Commission's perspective more broadly and key features between tokens that are utilities and tokens that should be properly viewed as securities?
Yeah, and I think this is kind of changing too, because one of the things I really want to signal is that we're going to help you try to figure out whether something's a security or not a security, but we want it to be a world where if it should be a security, you're not scared to have it be a security, because we will work with you then to figure out how the rules work for securities that are, in crypto form as opposed to in some other kind of form. And so I think we may see a change in the landscape, but I also think it's important to realize that this technology is not a financial technology. It will be used for other things, I think. Other people think that it's primarily a financial technology, but I actually think it has a lot of potential uses. And so we're going to see a lot of things that are simply not securities. And then, as you say, there are some that are, sort of the coin of whatever the blockchain is. They're what makes you be able to use that blockchain And I don't know that that is the kind of thing we're trying to capture with the securities laws. I think there is a separate question of whether you take something and you sell it in a transaction that's a securities transaction. And so this is the issue that we in Congress are wrestling with, of how we can provide guidance about how you'd go about doing that transaction and how you think about how long the token is deemed to be associated with the investment contract. And so that's what we're working on providing some guidance around.
So we've mentioned guidance a couple times. We've talked about legislation. We've talked about the idea of potentially rulemakings by the commission. What do you see as the potential timeline for actions by the FCC? Is that a fair question? You anticipated that question.
I mean, tell me when the government's going to reopen.
Fair. That's fair.
So I've been answering phones a lot during the shutdown, and sometimes people will call in, they ask for help, and it's something I can't help them with. So I say, you don't have to wait till the government reopens. They say, okay, when is that going to be? But no, I think that if we can reopen soon, I'm hoping that we'll get something done by the end of the year or early in the new year. But it is really hard to predict that, because this really has sort of changed all of the timelines. And this is going to be an ongoing process, right? We're going to need to do some rulemaking, and that does take a long time. But I hope we can get some proposals out of the building, in the first half of next year.
All right, I only have one more question, but Corey, go ahead. You got something?
No, I was just going to, and thank you, Commissioner. I'm curious what level of coordination you may or may not have with foreign governments. I mean, I obviously worked on Genius for 3 years, and it's been encouraging to see Secretary Besant go over to the UK and form this transatlantic task force on stablecoins. But it's a question that's popping up all over the world. I mean, Canada just announced that they're going to do a prudential framework for stables. For a while, we had to negotiate to keep USDC on Canadian exchanges through their securities framework, because they didn't have a prudential framework. So I think that might be interesting.
Yeah, we're very interested in working. I'm certainly have been talking to foreign regulators, interested in working with them. I'm glad to see the coordination with the UK. I have suggested that we think about a joint sandbox that would allow someone who wants to offer a new product or service in both jurisdictions to do that in a way that's streamlined, and that, again, the goal is to get to a permanent regulatory regime. So I think if there are other jurisdictions that are interested in that, it's something that we should explore. We can't ignore that there are differences in how we approach regulation, and I think that's one of the challenges. And I think another challenge is we've seen in the past, we've tried to do mutual recognition, and I think that is a very valid goal, but we have to make sure that we do it in a way that really does enable someone to say, I am complying with this other jurisdiction set of rules instead of yours, not a line by line, rule by rule comparison. And so I think that this is an opportunity for us to try some mutual recognition substituted compliance as well. And of course, we have to cooperate around enforcement issues.
Just staying on enforcement, so now I have two questions. Staying on enforcement, I think this is legitimately a softball question. Do you anticipate a change in enforcement approach by the staff as it relates to digital assets and crypto assets specifically?
I think you've seen a change already, but I would caution people who seem to think that we're in an era where they can do anything and there's no enforcement, that we still have an enforcement function at the SEC. And so we are certainly stand ready to use it in appropriate circumstances. And I think it's going to be regular way. We have rules and we enforce those rules, whether it's relating to crypto or something else. And that's what people should expect.
But I also think, I don't want to put words in your, so I'll just say my perspective based on what I have heard so far from the chair, which is, one thing that he said, and it goes back to when we were both on the commission, and there was this debate about enforcement priorities, and I remember Chair Atkins saying something along the lines of, everybody hates fraud. Everybody wants to protect investors, right? No matter what your political party is, what your ideology, the fact is that is one of the core missions of the agency. And so, fast forwarding to the current administration, I think our collective expectation, to your point, is that where there may have been areas in the prior administration where there are these kind of gray area questions, maybe an expansive interpretation of or application of the Howey test, that led some of the enforcement activity. I think what people are anticipating is more of a focus on really core protecting investors from harm, thinking about instances where people are using things that may be labeled as a digital asset, may be labeled as a cryptocurrency, but are traditional, fraud. That's a place where we can continue and should continue to expect the SEC to be pursuing enforcement actions. Is that, would you say, a fair
Yeah, I mean, you
statement?
said it much better than I ever could, but I do also think we need to acknowledge the fact that some of the bad conduct that's happening in the crypto world probably is not within the SEC's jurisdiction either, because it's happening outside the US, or it's just not our issue. And so it is important for other regulators, for DOJ to be able to bring those kind of cases as well. And then I think another thing the industry should be doing is it should be helping to try to clean up the bad conduct. There's so much bad stuff happening, and it's not in anyone's interest to have that. Anyone who's trying to run a legitimate business, it's not in their interest to have that either. And so make efforts to educate your customers, to help them figure out what to watch out for, report when you see bad conduct. It's just quite distressing to see how many people have been hurt in the name of crypto. It's often doesn't involve crypto at all, but it can be in the name of it. So we really need to make an effort to stop that.
All right, my last question, unless the group has something else. No, okay. So my last question, so you've got obviously an all-star group of folks on the panel. We've got 50 or so folks in the room. We've got hundreds of securities lawyers and practitioners online. So what advice would you give people that are advising firms on digital asset issues, whether they're at those firms themselves or whether they're outside counsel? And I'll just stipulate, I am a pretty conservative securities lawyer. And so I am, my risk tolerance for these kinds of issues is not particularly high. But folks have clients that have questions. They want to experiment. They want to innovate and create opportunities for investors or utility through some of these kinds of assets and blockchains. What advice would you give practitioners as they're thinking about advising clients or advising their peers if they're at firms on some of these kinds of issues?
It's a very difficult area to be a lawyer in, because even now there's more guidance out there, but there's still a lot of things that need to be filled in. And so my advice is really encourage people to come and talk to you before they have launched something, so that they can really be thinking about how to do that in a way that is compliant. And then the second thing I would say is help us do our job well, so that the rules that do come out are ones that make sense for what your clients are trying to build. And so the more we can hear from people like you who are in the trenches with actual clients trying to do actual things, the better I think the rules will be. So please, my door is open, task force door is open.
At least figuratively for the time being, right? But it will be literally soon.
No, the task force door is not now open. Mine is actually open now, so you can come talk to me now. Just contact me directly. Don't try to go through any staff.
Okay, perfect. All right, well, we're going to wrap it there. We're going to take a break. Commissioner Peirce, thank you so much for the time. Thank you for joining us this morning.
Thank you all for your time. I appreciate it.
Okay, so we're going to take a break. be back here by 10:54. We're starting at 10:55. Come back by 10:54, please. Thank you all very much. Thank you, guys.